Luke and Peter, are you able to see the PowerPoint slide on the screen? Okay, thank you. So we'll give it about 2 minutes, and then we can probably begin, even 3 minutes, because there's just the two of you. But there should be other students that should be joining us in a few minutes. Hello, Martin. I guess we could begin. So tonight, we're going to be talking about privity of contracts. But before we do that, I wonder if there's anything you may want to discuss first or anything you'd like to take up before we start tonight's tutorial. And I thank you for joining tonight's session again. So we've got Luke, Heidi, Peter are always there, and Martin as well. So thanks. And Martin, I actually saw the post you had on the forum. I haven't had a chance to actually just read through it, but I will. And when I do, I'll try to post a response. But I'm very happy about the fact that you have been suggesting an alternative way to answer the factual scenario that was part of the legal memorandum problem. So that's good. I just haven't had the chance to go over what you wrote there, but that's really good. Thanks for that. So would anyone wish to say anything before we start tonight's tutorial? So I suppose not. Okay, so we could begin. So tonight we're going to be discussing the final topic on one of the general principles of contract law before we go to the statutory aspects of contract law by looking at the Australian consumer law next week. But in the meantime, we're looking at the common law principles of contracts, although as you will probably have noticed, there have been some changes in the law of contracts in relation to the principles of privity because of some statutes that have been passed in relation to it. In particular, for example, the Land Protection Act of 1974 of Queensland, which has kind of abrogated the rule on privity. But we're going to be discussing that, I think, in the context of the factual scenario that we have right now. So for tonight, we're going to be talking about the privity of contract. And as you well know, the privity of contract essentially says that only those who are parties to the contract may be the subject of benefits, or maybe the subject of some detriment or any liability. That simply is because one, if a person is not a party to the contract, then obviously that person couldn't have been part of the consensus ad idem. That person couldn't have been part of the meeting of the minds because that person is not a party. But more importantly, that person would have lacked the consideration. in order to then be able to successfully assert that that party should benefit from whatever is contractually stipulated. And obviously, that raises the question of whether or not the rule of privity is actually just a way of rephrasing the rule of consideration, or whether or not it is actually a freestanding principle of its own, as distinct from the principle of consideration. I think that will be something that we can check as well as we go on tonight. So tonight, when we discuss the topic on privity of contract, we're hoping that at the end of after studying this topic, you should then be able to discuss and explain the fundamental rule of privity, which states that only a party to a contract may enforce the contract. The statutory scheme in Queensland as well, which allows parties to make a contract for the benefit of a third party, and then allows the third party to enforce the contract if the third party has accepted the contract. And finally, the common law exceptions, which have been developed to try to deal with injustice which may be created with a simple application of the doctrine of privity. So because, as we've already noticed, the principle of privity does often lead to an injustice, because it may be possible that there are two contracting parties. For example, it could be a company and a father of a child who enters a contract with a company for the benefit of the child. And let's assume that the father at some point dies and the father is no longer able to, or that the father might be permanently disabled and is no longer in a position to enforce his rights under the contract. The question then is, will the child be able to acquire the benefits as stipulated in the contract between the child's father and the business? And the rule of privity will tell us that that won't be the case. And that's essentially the case of Coles, the case of Coles, where a wife was actually a party to the contract, in the sense that she had actually signed the contract, was unable to reap the benefits of that contract because, in a sense, she was a real party, because she had not actually been able to provide any consideration to the contract, although her husband did. So this is a very interesting topic, mainly because there are a lot of opportunities for there to be injustice as a result of its strict application. So we will go deeper into the principle of privity by looking at a factual scenario, and then we'll just take it from there. Can I get a volunteer to read the tutorial question?
Yeah, can you hear me all right?
Good. Thank you.
Margaret and Alex had been dating for a few months before Margaret learned she was to leave Brisbane and spend 6 weeks in London on a work assignment. While she was away, Alex decided to surprise her by remodeling her kitchen. She had said that she was thinking about updating the very dated 1970s flat. Alex had a key to the flat and had promised to
Peter, hold on, Dennis.
Sorry, you're cutting out. I can't hear you.
Wait, there's a problem with your mic. It's not sound. Hold on. Wait. Okay, there seems to be a problem with Peter's microphone. Can I get another volunteer? There's too much noise coming from Peter's mic. Can I ask somebody else to read the tutorial question for us? Luke, Heidi, Martin, Chris, volunteer. Luke. Okay, thank you, Luke.
Yeah, not a problem. So would you like me to start from the beginning?
Yes, please.
All right. So Margaret and Alex had been dating for a few months before Margaret learned she was to leave Brisbane and spend 6 weeks in London on a work assignment. While she was away, Alex decided to surprise her by remodeling her kitchen, as she had said that she was thinking about updating the very dated 1970s kitchen in her flat. Alex had a key to her flat and had promised to drop by every few days and leave some lights on so that it would appear somebody was at home. Alex made a contract with Steve, a kitchen designer and installer. Alex selected a colour and benchtop scheme and a range of appliances. Steve undertook the installation, and Alex waited with breathless anticipation for Margaret to return from the UK. When Margaret returned from the UK, she was absolutely incensed. She hated the colour scheme and the appliances, and she was appalled that Alex would have taken it upon himself to so fundamentally change her home without even asking her. She dumped him on the spot and told him she never wanted to see him again. Heartbroken, Alex changed his number and moved to Western Australia to work in the mines. Worse was to come. Margaret soon discovered that Steve had done a poor job of the kitchen installation. The appliances did not work correctly, and the wet areas were not waterproof. She had no option but to get a competent kitchen tradesman to repair the mess. She then tried to sue Steve, but Steve refused to even talk to her. As far as he was concerned, he had been hired by Alex, and the contract had been completed when Alex signed a form saying he was satisfied with the work. Margaret has come to you for advice. Can she sue Steve for the cost of repairs? Could she do so if these events had happened in a common law environment? For the purpose of this question, assume the ACL does not apply and that there are no industry-specific requirements. Also assume that Margaret's intended remedy is open to her if she is able to sue. We are only interested in the privity question.
Okay, thank you, Luke. Would you like to post your answers in the chat box? Or if you're ready, you can actually start using the mic to try to answer the tutorial questions. So we need to answer the first question. Can Margaret sue Steve for the cost of repairs? So from Luke, he says Margaret could. Martin says no. Okay. And I'm just going to transfer your answers to the screen. Okay, can I get some answers from the others? Okay. So from Peter, she cannot enforce the contract. Luke, perhaps you want to begin by explaining your answer, if you could, if you want to.
Yeah, sure. I kind of saw it in two parts, as in Margaret can accept because by conduct, she's actually continued, she hasn't straight gone and said, no, I don't accept this. She's actually gone and inspected everything and has then realised that a lot of this workmanship wasn't right and the appliances didn't work. So from how I could see it from a conduct perspective, she's accepted. But then I just had a quick look at the textbook and saw the part about how the assent can be communicated by the beneficiary or on behalf of the beneficiary. So, Alex has actually gone and made acceptance by getting Steve to do that, even though he hasn't asked permission. So that's just how I saw the situation.
Okay. So in both cases, we have you stating something about Margaret accepting the contract, and we also have Martin saying something about Margaret not accepting the contract. why is this relevant? Why is this issue about accepting the contract pertinent to the discussion on in tonight's discussion, or in trying to resolve the tutorial problem? What has acceptance of the contract got to do with anything?
Queensland is a statutory exception to the common law principle of privity.
Okay, go ahead.
Essentially, if the third party accepts the contract, either by conduct or words, they can enforce it.
Okay, so that's assuming that Queensland, that this happened in Queensland. So Martin, you're saying that assuming that this actually occurred in Queensland, then it's possible to argue that under the Property Law Act of 1974, Queensland, it would be possible for Margaret to sue on the contract, assuming that she has accepted the contract. That is what you're saying, Martin.
I'm saying that in principle, yes, but in actual fact, he didn't accept the contract.
Right.
He said, "Hell no," broke up with him, and so on and so forth. So,
Very good.
both are that kind of words. He hasn't accepted it.
Very good. How about you, Luke? When you were talking about accepting the contract, were you also talking in the context of the Property Law Act of 1974, Queensland? Or was it in connection to the general principles of contract law?
No, I was working off the Queensland legislation. Yeah, I must have just not quite gotten it. So,
okay. So we have a situation where under the Section 55 of the Property Law Act of 1974 has the effect of abrogating in Queensland the rules of privity, that it's possible for a third party who is not actually a party to the contract, who is not an original party to the contract, to actually enforce any rights, benefits, or liabilities under the contract if that third party subsequently accepts the contract. And in that case, if the third party accepts the contract, then effectively that party becomes almost a party to the contract and can then sue on the basis of the benefits, but could actually similarly be sued for whatever liability might be stipulated in the contract. So that is the Property Law Act of 1974, which, as I said, Section 55, which, as I said, at least in the case of Queensland, has the effect of abrogating the principle of privity of contract, which is a very strongly held principle in the common law of contracts. But in this case, it is difficult to argue that there is an application of the Queensland legislation, mainly because the requirement of Section 55 of that specific Queensland legislation is that the third party must have accepted the contract. And that hasn't happened in this case. Now, let's assume that, so in this case, we know that Queensland law does not apply. The question is, if we apply, therefore, the common law, would it be possible for Margaret to sue on the contract? Can Margaret enforce the contract? Wait. Can you hear me? Hold on, what's going on? What's going on here? Okay, from Luke, possibly by Unjust Enrichment. And then we have a question from Martin. Okay. Now, before I answer the question of Martin, and let me just make sure that I'm able to capture all the answers here. Okay. Now, how would one properly approach a problem such as this? What's the best way to answer this? How would we approach? What's the proper way of answering this question? Can somebody attempt to do that? So if this were part of a final assessment and we had this type of question, how would you approach this question? How would you come up with a response? What's the proper way to answer this? So the way to respond is always to begin with general principles of contract law. And then you examine whether or not certain exceptions apply. Okay, so having said that, what is the general principle here that you can apply to the factual scenario? Okay, so for Martin, identify the issues, then approach them. So what would, is it about contract formation? So what exactly is the principle that is involved here? Is it about contract formation? What is the legal issue here? Okay, privity. So if you were to phrase that, it is a privity issue. How would you phrase the legal issue? So, for example, can Margaret sue on the contract, or can Margaret enforce the contract, or sue Steve for the cost of repairs, given that blank? So how would you phrase that question there as a legal issue? So obviously it's about privity, so that's correct, that's good. And as Peter pointed out, the contract is only between Steve and Alex. So how would you, if you were to phrase the legal question so that, in other words, having identified the legal issue, we can then try to state what the relevant legal principle is. So we begin by, okay, good. So we've got something from Martin here. Okay, good. So then I'm just going to post what Martin has said. So this is from Martin. Is Margaret a party to a contract? And what do the rules of privity say about her ability to see upon the contract? Okay, so if I were to state this, the legal issue probably is Margaret able to sue Steve for the cost of repairs, given that Margaret is not a party to the contract between Steve and Alex? In other words, there is no privity of contract between Margaret and Steve. So if I were to rephrase the legal issue again, or if I were to phrase the legal issue, it would frame the legal issue as, can Margaret sue Steve for the cost of repairs, given that, one, Margaret is not a party to the contract between Steve and Alex, and two, there's obviously no privity of contract between Steve and Margaret. So if that is the legal issue, what is the rule? So what is the rule there? Can somebody state for us the general rule in relation to the legal issues? Very good. So in relation to the legal issue that I just framed, if the rule is only parties to the contract may sue. So it would appear that if we follow the general rules, the general contract rules under common law, then only parties to the contract may sue, based, for example, on Dunlop Pneumatic Tire Company versus Selfridge. So that would be the general rule. Okay, so good. We're getting there. So we know that under general contract law, based on the common law, only the parties of the contract may sue. Given the fact that Margaret is not a party to the contract, it would appear that Margaret cannot sue Steve for the cost of repairs because she is not a party to the contract between Steve and Alex, and neither is there a privative contract between Steve and Margaret. So on that basis, given the fact that there is no privative contract between Steve and Margaret, Margaret cannot sue Steve for the cost of repairs. So we know the general rule now. However, there are certain exceptions to the rule on privity. What are those? We need then to examine if some of the exceptions to the rule on privity can apply in this case, which would then enable Margaret to sue Steve for the cost of repairs, even if Margaret actually is not privy to the contract. Even if there is no privity of contract, we want to examine if there might be certain exceptions under the common law which would entitle a party who is not a party to the contract to sue on the contract. What might those exceptions be? Okay, so very good. So let's look at the exceptions, and I'm going to erase what we've discussed so far. And remind me, Martin, to go back to the question that you raised. So we're looking now at the exceptions to the general rule. So in other words, the way to logically respond to a problem such as this is to state the general rule first and then determine if there might be exceptions to the rule. And in terms of answer, some of the exceptions will be the issue of trust. So that would be the other one from Peter, would be treating one party as an agent. So you have got the agency. You've got rules and exception as an exception, the rules on agency. What else? There's also the one on unjust enrichment. Is there a fourth one? What's the fourth one? Very good. So there's collateral contract. Can somebody explain to me each of these exceptions, at least one of the exceptions? Can I ask one of you to just, maybe one that you cited, can you just use the mic and explain to the rest of the class what each of these exceptions provides? So can each of you explain the exception to the rule on privity? Okay, so we've got an answer of Martin. Hold on. So this one is from Martin. So for Martin, there are 4 possible exceptions. There are 4 possible exceptions. That an implied trust was created by Michael in favor of Margaret in relation to the contract, that Michael was acting as Margaret's agent, that equitable principles of unjust enrichment allow Margaret to sue, or that there was a collateral contract. Can I just ask someone to explain each of these exceptions? Can you just, pick one of these exceptions and explain it? What do these exceptions provide? What do they state?
Well, the unjust enrichment one
Yes.
is where the beneficiary, where one party of the contract is going to gain a vast amount from not fulfilling or from refraining from doing something in the contract.
Yes.
So if they, for example, don't fulfill their part of the bargain and the beneficiary misses out, then that's comes under unjust enrichment because they're benefiting from not doing something that they should have done.
And in that case, that would entitle a non-party to the contract, meaning a third party, to actually sue on the contract. Very good. So What has happened is that in response to the rigidity of the common law principles of contract law, equitable principles have stepped in. So whereas common law principles would generally prevent a third party from suing on a contract, the equitable rules of principles have been developed by the courts that then enable third parties to sue on the contract. So even if there is no privative contract, equitable rules have been developed by the courts that then allow non-parties of the contract to sue on the contract. If, for example, there is an unjust enrichment as stated by Luke, in that case, equitable principles would state that it would be unjust and unfair for a party to the contract to gain a windfall or a profit, a vast profit from the contract by not performing the contract simply because a beneficiary who is not a part of the contract is unable to sue on the contract. So to address that inequity, that injustice, equitable principles have been developed that would then enable a beneficiary who is a third party to the contract to sue on the contract. Very good. That's one. Can somebody explain the others? How about agency or collateral contract or trust?
I can explain one.
Thank you, Martin.
Essentially, the trust, when someone declares a trust, they say that the benefit of something, in this case the contract, is actually for Margaret, and thus by declaring it to be in trust, that benefit in equity belongs to Margaret, and thus she would be able to sue.
Very good. So the principles of equity come in, which is a distinct field of law related to contracts, but it's a separate field of law related to equity. So it's in this case, in a contract, as pointed out by Martin, it may be possible that one of the parts of the contract is actually considered or implied by law to be the trustee of the beneficiary, or who is known as the statutory trust. In that case, the beneficiary, for example, will benefit from the actions of the implied trustee. In this case, the implied trustee is Steve, who acts for the benefit of the beneficiary, who is Margaret. So that would be the principle of trust. And we will examine whether or not these exceptions actually apply in a short while. We're just covering for now the general statement of these exceptions, and then we will try to apply each of these exceptions to the factual scenario. Thank you, Martin. How about in terms of the exceptions concerning agency and collateral contract? Can somebody pick that up and explain it to us? So how does the rule on agency and collateral contracts work? What are they about?
Agency is where you're not making a contract. If you agreed that you're not making a contract, you're not acting on your own behalf, you're acting for someone else.
Yes.
So it can be distinguished from a trust where it's you are acting on your own behalf, but the benefit belongs to the beneficiary. An agent, you're actually acting for them. They are the other party, you're acting for you.
Very good. Thank you, Martin. That was really well explained. Thank you. Can somebody explain the exception on collateral contracts?
Yeah, I'll
Luke?
have another go.
Thank you.
So the collateral contract is where parties A and B will make a contract, but it's in relation to party C where B and C are going to make a contract. So A and B will make a contract if parties B and C make their contract. So it's in reliance of the second contract being made.
Very good. So that second contract actually is part of the original contract between party A and B. In that case, therefore, we can see that in a sense, party C is actually a party to the contract because the second contract between party B and C are actually in consideration of the first contract. Very good. So that's what Mary says. More than that, the second point is actually the consideration for the first. Thank you. Okay, good. Now, applying so we've already stated that as a general rule, it would be legally difficult for Margaret to sue on the contract because she is not privy to the contract. So the rules on privity will prevent Margaret from enforcing the contract between Steve and Alex, and it will also prevent Margaret from suing Steve for the cost of repairs, mainly because Margaret is not a party to the contract, and there's certainly no privity of contract between Steve and Margaret. So having said that, we then begin to determine whether or not there might be a possibility for Margaret to be able to enforce the contract nonetheless and sue Steve for the cost of repairs on the basis of exceptions to the rule on privity of contract. Let's begin by looking at the exception concerning trust. Is it possible to apply the principles of trust in this case in order to enable Margaret to sue Steve for the cost of repairs? Is it possible to argue? I think there was an earlier statement that I think somebody said something about trust. Is it possible to apply trust principles here to enable Margaret to sue Steve for the cost of repairs? Okay, so we have an answer here from Martin. Possibly, an implied trust can be verbal, but the issue is, where is the declaration, even implicit? So as a general rule, if we apply principles of trust, there must be a declaration, as pointed out by Martin, that the trustee is actually entering into the contract for the benefit or in trust of a beneficiary. And in this case, it is difficult to see that there was an attempt on the part of Luke to actually designate Margaret as the beneficiary of this contract. That seems to be a problem. That's so as a problem, as a question of fact, it's difficult to see on the basis of the facts that there was that a trust can be implied on the basis of the actions of Steve. It's difficult to assert that that Steve had attempted to create a trust in favor of Margaret, because that is not shown by the facts. Now, but more importantly, what exactly is the status of the application of trust law in contracts? Is that a settled exception? Is it well accepted that the rules of trust can generally be, is it Alex or Steve? Oh, sorry, rather Alex. Sorry. Yep, I got confused on the fact there. So Alex is the friend of Margaret, and Steve is the one being sued. So it's difficult to see that. We've got somebody here who says Michael now. It's not Michael either. We're actually talking of Alex potentially being the agent of Margaret. So the question is, did Alex act in such a way that he ended up impliedly constituting a trust in favor of Margaret? So it's actually Alex. So thanks for pointing that out. So going back to that question, is it a well accepted now that the principle of trust can generally be used as an exemption to the rule on privity of contracts? So we've got an answer from Martin here. I'm just going to put them on the screen, mainly because the chat box isn't actually visible in the recording. No, it was the judges in Trident Insurance that espoused it arbiter, and it was more about avoiding injustice. So that's right. The law is actually not well settled. In fact, a law is likely to lean against the application of trust law as an exception to the rules of privity in contracts as developed by the common law. So the case of Trident Insurance versus McNeese seems to be quite exceptional, and it was mainly to avoid an injustice where 2 points. One, you might say that in that specific case, it involved a contract of insurance, a kind of commercial contract where one would think that when somebody enters into an insurance contract, it is likely to be not just for the benefit of the person who is the one who entered into the contract. It's likely to designate other beneficiaries, so are third parties to the contract, and that those third parties may possibly, as in that case of Trident Insurance versus McNeese, rely on the existence of that contract. So the law is not settled that trust rules can actually be used as an exception to the rule on privity of contracts. It's not well settled, and secondly, the current jurisprudence actually leans against the application of trust principles as an exception to the rule on privity of contracts. So we have two problems here against the application of trust, the principles of trust, as a way of allowing Margaret to sue Steve for the cost of repairs. So the factual scenario number one does not seem to show that Alex, when he entered into the contract with Steve, actually intended, expressly or impliedly, to designate Margaret as the beneficiary under the contract. And two, the rule on trusts as an exception to the rule on privity of contracts is not well settled, and more than the fact that it is not well settled, the current jurisprudence leans against the application of trust principles as an exception to the rule on privity of contracts. So knowing therefore that the rule leans against the application of trust principles, it is unlikely for courts to apply trust principles in this case to favor Margaret. It would be difficult, mainly because we should see the case of Trident Insurance versus McNeese as an exceptional or as a unique case where one of the justices allowed, or Justice Dean rather allowed, stated that it was possible for trust principles to come into play to enable a third party who was not obviously a party to the contract to sue on the contract. So that would be exceptional, and therefore it is unlikely to be applicable in most other contexts. And so that's right. So we're talking of constructive trust as opposed to an express trust. Now, we don't want to go into the notion of into the rules of equity here, because that is actually a topic you'll be discussing later on. Let it just be said that generally, if you look at the development of trusts, a trust is usually created expressly by a trustee for the benefit of a beneficiary. Equity will step in so that even if there is actually no express trust, the rules of equity will step in to enable a person, a third party, to be considered a trustee, impliedly, as a way of dealing with potential injustices. So we're talking of constructive trusts here, as Martin pointed out, but we don't want to go into the details of trusts and equity because that is a separate topic altogether. But it is important that we are able to be exposed to that principle because it is recognized, it has been discussed as a possible exception to the rules of privity of contract law. Now, how about agency? Can equitable estoppel be used? Okay, good question. Can somebody try, look, do you suppose you might be able to explain to us the principle of equitable estoppel, if you could? Or maybe somebody else? Yes?
Yeah, sorry, I was just was having a look through the textbook and I just saw the equitable estoppel section just after trusts, and
Yes.
that's why I brought up the question, because it goes into about unconscionable conduct.
Yes.
That's why I was wondering if it is relevant to the trust sort of situation, because she has could rely on an estoppel because of unconscionable conduct on the part of promisor A, as in Steve.
Okay, that's good that you're raising that question. So generally, if you're talking about the equitable rules concerning estoppel, the assumption here is that where a party or a non-party has relied on a promise or benefit as stated in the contract to his or her detriment, it would then be inequitable not to allow that person who relied on the representation or the promises made by a party to the contract to sue on the basis of that promise. So equitable estoppel will step in to prevent injustices to a party who has relied on the representations or actions of another person, to then be able to sue on those representations or those promises, even if the general rules of contract law will not apply, either because one, it might be said that that person who is attempting to sue has really not provided any contribution and therefore would have been unable to sue on the contract, or two, because there might have been no privity of contract between them. So the rules of equitable would apply in that case. But the question is, under the facts, would equitable estoppel actually apply? Would it actually be relevant? So point one would be, were there representations made by Steve? So that would have to be the first relevant question. Would there have been representations that were made by Steve to Margaret? And two, did Margaret rely on those representations made by Steve, if they were actually made by Steve? And three, if the reliance by Margaret on Steve's representations, the question then is, would it be to the detriment of, and that whether she actually acted on her to her detriment, and fourth, whether or not by preventing Margaret, for example, to sue on the representations made, for example, by Steve, would it not then mean that there would have been injustice that would have been perpetrated on Margaret? It would appear that would not be the case, because here we cannot see any representation that was made by Steve to Margaret. It's not in the facts, and obviously Margaret did not act on those representations, and Margaret did not do anything to her detriment, and there's obviously no injustice that can be said to have happened to Margaret as a result of possibly relying on the representations of Steve. Now, in terms of the rules of agency, we have an answer from Martin here. And I'm just going to put it a bit to the top. Trying to think what to do here. Okay. So from Martin, agency fails because it's completely contrary to the rules of the agency. For someone to be someone's agent, at the very least, they need to know about it. He could have unilaterally declared a trust, but he can't unilaterally declare an agency. So, in other words, if you speak of agency as pointed out by Martin, you would then have an agent who is actually acting in behalf of a principal. But in that case, the assumption is that there is an agreement between the principal and an agent. So you can only have an agency if there is an agreement between the principal and the agent, where the agent acts for the benefit of the principal or acts under the authority of the principal, so that the actions of the agent are actually the actions of the principal. So that would be the application of the rule of agency. But in this case, clearly, Alex acted on his own. It cannot be said that he was acting as an agent of Margaret, who was his principal. So it's difficult to apply the rules of agency here. Pointed out by Martin, he can't unilaterally declare an agency. Now, the principle of agency is crucial. The reason why we can't simply say that a person can just unilaterally create an agency is because, remember that the assumption is an agent acts in behalf of the principal. What it also means is that the agent can actually make the principal liable, because the agent acts on behalf of the principal. Any of the actions made by the principal, made by the agent, actually bind the principal. And therefore, it will be, the law will not allow somebody to just unilaterally declare the existence of a principal-agent relationship in the absence of an actual agreement, because of the danger that the agent ends up binding a principal without his knowledge or his consent. So under the scenario, we can see that the actions of Alex were never with the authority of Margaret, and therefore it's difficult to argue that Alex was acting as an agent of Margaret. So the rule of agency will have to apply. Will not be able to apply, cannot be applied in the factual scenario. Now, so again, agency is a different topic of law altogether, because, as I said, we're discussing this anyway. We might as well kind of get into it a bit. As a general rule, would you know if it's actually possible for Alex potentially to have entered into an agreement with Steve as Margaret's agent, assuming that there was an agreement between Margaret and agent, between Margaret and Alex? Would it actually have been possible for Alex, acting as an agent of Margaret, to enter into a contract with Steve that would then bind Margaret, even if Alex did not disclose the identity of his principal, who would have been Margaret? Assuming a factual scenario where there is an agreement between Margaret and Alex for there to be a principal-agent relationship between them. But the question is, assuming that were to exist, would it be possible to bind Margaret to the contract as an undisclosed principal? Again, we're not going to be going deep into this, but because it's part of the topic, we're kind of just discussing it a bit. But it is meant to be covered in a different course and not in contracts. But we're taking it up anyway because we just want to have better understanding of these exceptions to the rule on privity of contract. So we're talking about the undisclosed principal. Can a principal be who is undisclosed or who is unidentified potentially be bound under the contract if the contract between the agent and party B, for example, in that case, party B is unaware that the agent is actually acting in behalf of a principal? What is the rule there? Okay, we're running out of time, so I'm just going to answer that. So the general rule in agency is that it is possible for an undisclosed principal to actually be bound under the terms of the contract, even if the other party is unaware of the existence of an undisclosed principal, for as long as the agent is acting in behalf of the principal. That is a sound rule because remember that the agent is aware that he is acting for the benefit of the principal, but acting under the authority of the principal. In other words, not only does it mean that the agent is acting on behalf of the principal, it also means that it is not the agent personally who is meant to be liable under the contract. It is meant to be the principal who is liable under the contract. And so therefore, it will be unjust if knowing that the agent is not acting for himself, but is acting for the benefit of a principal, it would be unjust if simply because the other party is unaware of the existence of the principal, the agent then becomes personally liable under the contract. Because that is exactly the whole point about the agency, the rules of the agency, that the agent is not meant to be personally liable on a contract if it was actually acting for the benefit or under the authority of a principal. So the rule is, even if there is an undisclosed principal, in other words, the other party to the contract is unaware of the existence of the principal, the fact will remain that it will be the undisclosed principal who will be bound under the contract, and it will not be the agent who is the party to the contract. It will actually be personally liable under the contract. It will still be the undisclosed principal. Okay, so we've covered trust, we've covered agency. What else should we cover here? So we know that trust cannot apply. It's difficult to argue on the basis of trust. It's also difficult to argue on the basis of agency. How about in relation to unjust enrichment? Can somebody explain this to us? Would the principle of unjust enrichment apply?
I think the principle would apply mainly because Steve has actually benefited by getting paid through the contract, but he's done a dodgy job of it. So he's been compensated, but now Margaret's suffering. So I think she would be able to follow that principle to sue.
Okay. Comments from anyone else? Thank you, Luke. Comments? Do we have a comment from anyone? A response to what Luke has just said? Okay, we're running out of time. So I would argue that the exception concerning unjust enrichment is unlikely to apply. Hold on, we've got an answer here. So okay, so we've got an answer here from Martin. So I'm just going to post it on the screen. Just put it on top. So this is from Martin. Where are we? My recollection of restitution is a little hazy, but it applies where Steve obtains a benefit at the expense of Margaret, and it is unjust. My thinking is that it may not help her. If he did the job on the cheap, for example, and made $50, that's the benefit. So she may not recover all she needs to. So, Martin would actually be correct. The exception concerning unjust enrichment is unlikely to apply because it's difficult to argue that Steve is unjustly enriched. The principle of unjust enrichment would typically apply where one of the parties to the contract has actually not fulfilled his bargain under the contract, and because of that party to the contract who has benefited from the contract has actually not performed his obligations on the contract. To perform the obligation of the contract, it's that the other person for whom the contract would have been a benefit cannot sue on the contract because that person, the possible beneficiary, is not the party to the contract. So in this case, it's difficult to speak of unjust enrichment, mainly because we will notice Steve has actually performed his bargain under the contract. He has performed his part. So it's difficult to assert that there has been an unjust enrichment on the part of Steve. He has, in fact, performed his bargain under the contract. He did what Alex asked him to do. And more importantly, we will notice under the facts that Alex actually was happy with the way that Steve performed his bargain under the contract. So the facts state that Alex signed a form saying he was satisfied with the work. So for that reason, it is difficult to argue that there has been unjust enrichment, because in fact, Steve has performed his bargain under the contract. You can only argue that there has been unjust enrichment if one of the parties to the contract then does not perform his bargain. But if that person has already performed his bargain, meaning the contract has been executed, you cannot have unjust enrichment. So unjust enrichment will only apply if one of the parties to the contract refuses to perform his bargain under the contract, and as a result of refusing to perform his bargain under the contract, he then is unjustly enriched at the expense of a beneficiary who is not a party to the contract. In this case, we clearly see that Steve has performed his bargain under the contract, and more than that, Alex is actually signed a form saying that he is happy with the work of Steve. And we know what collateral contracts is about. It's difficult to argue that there has been a collateral contract because the contract between Steve and Alex did not take into account a possible further contract between Steve and Margaret, for example. So that when Steve and Alex entered into the contract, they entered into a contract not knowing or not agreeing that as part of the consideration there was going to be a collateral contract with Steve and Margaret. So the rule on collateral contracts will not apply here as to enable Margaret to sue on the contract. So, having said that, okay, but there's a question here from Luke before we wrap this up. So should she sue Alex instead? Alex being the party to the contract. Very good question. So can Margaret sue Alex instead? The question there is assuming that Margaret were to attempt to sue Alex, is that on the basis of contract law? So the answer is, appointed by Martin, yes, Margaret can possibly sue Alex, but it will not be on the basis of contract law. It could probably be on the basis of courts, but not on the basis of contract law. Mainly because, as we said, there is no contract between Margaret and Alex. So for that reason, while perhaps Margaret can sue Alex on the basis of torts, it can't be on the basis of contract because there is no contract between Alex and Martin. Sorry, between Alex and Margaret. So just to wrap this up, the answer would be that on the basis of the facts, because there is no privity of contract between Steve and Margaret, it would then be difficult for Margaret to sue on the contract because of the rules of privity of contract, which provide that only parties to the contract may sue on the contract. And we know as a rule that privity of contract actually is a freestanding principle in contract law as opposed to consideration, because it is possible for somebody to be a party to the contract, as in the case of Coles versus Bagot's executor, and yet because that person who applied to the contract by signing the contract has provided no consideration, that person would then be unable to sue on the contract. So that person, because in the case of Coles versus Bagot's executors, the wife, for example, was a party to the contract because she signed the contract. There was clearly a privity of contract between them, but because Mrs. Bagot did not provide any consideration, she couldn't sue on the contract. So therefore, privity of contract is a freestanding principle in contract law as opposed to the rule on privity of contracts, although we can see that consideration and the rule of privity are closely interconnected. So having said that Margaret cannot sue Steve for the cost of repairs because she is not privy to the contract, we then examined the possible exemptions, and we said the exceptions can't apply, as I've already explained previously. Okay, it's 7:05. That should be it. There was a question by Martin. Okay, if the third party does not accept in Queensland, do we revert to common law rules? Yes. So in the first place, the first question for us is, under the facts, does Queensland legislation apply? We don't really know, because we didn't say that this happened in Queensland. So we have to be careful there. Queensland legislation only applies if the transaction occurred in Queensland. The facts do not state that. Okay, but assuming that the transaction actually happened in Queensland, and therefore there was a possible application of the Land Protection Act 1974 of Queensland, which we know doesn't apply because Margaret did not accept the benefits under the contract. So the question for Martin then was, if a third party doesn't accept in Queensland, do we revert to common rules? So in that case, we then try to apply the common law rules. So what we need to remember is that the fact said that Margaret left in it. Oh, right, that's right. So the facts did say, yeah, I missed that. The facts did say that, yeah, so it seems, you're right. Thank you, Luke. It does seem that Margaret does come from Brisbane, and so therefore Queensland law could have applied. That's right. So thank you for that. But as pointed out by Martin here, they lost the file there. If Queensland legislation doesn't apply, the Land Protection Act doesn't apply, then we revert to the ordinary common law rules, because the effect of the Land Protection Act of 1974 Queensland would have been to enable a third party who is not a party to the contract to actually sue on the contract. That would have been the possibility there. But the requirement under the Land Protection Act 1974 of Queensland is that the third party must actually accept the benefits under the contract, which is not the case. Now, because Queensland law does not apply, then we need to apply common law rules here. And in this case, the lack of privity of contract between Steve and Margaret would prevent Margaret from suing Steve for the cost of repairs. Okay, any questions before we end tonight's session?
Yeah, I just had a quick question, Manjo.
Yes.
Through reading the situation again,
Yes.
Isn't there a contract between Margaret and Alex, because she's asked him to house sit for her and drop by every few days and leave some lights on? So would there be a verbal contract between those two as well?
That's right. And so assuming that there was a contract between Margaret and Alex, what would that then have to do with the possible right on the part of Margaret to sue Steve? Can it be said that that's a collateral contract? In fact, well, we're just making, remember, we made under the facts, we made an assumption that there was a valid. Okay. Yeah. In the first place, what exactly is the agreement between Margaret and Alex? So under the facts, Alex had a key to her flat and had promised to drop by every few days and leave some lights on so that it would appear somebody was at home. In the first place, the question is there a contract between Alex, at least a binding contract between Alex and Margaret? Assuming, we know that even assuming that there was a valid contract or a binding contract between Margaret and Alex, we know that still that will not enable Margaret to sue under the contract against Steve, because it doesn't fall under any of the exceptions. Okay, but going back to this specific context of a contract, so-called contract between Margaret and Alex, the relevant question is, going back to basic principles of contract law, is there actually a valid contract between Margaret and Alex? What was that contract, and would it have been binding? Margaret can sue Alex, providing get past the information hurdles. Alex that may be able to sue. Okay, yep. Okay, but assuming that Margaret can sue Alex, on what basis? Is it under contract law, or is it on the basis of torts? So the first question I ask is there actually a binding contract? So we're moving away from the question that was asked in this report. Okay, let's be clear. We've already answered the question. We have said that Margaret cannot sue Steve. That has been clear. But we're trying to backtrack a bit, and we're trying to wonder if somehow there was a valid contract between Margaret and Alex. Okay, and the answer is there might have been an agreement, but it is not a binding agreement because there is no consideration. Margaret has not provided any consideration to Alex's promise to drop by every few days. So that's the issue there. There is no consideration that was provided by Margaret for Alex's promise to drop by every few days and leave some lights on. Assuming that there was in fact a consideration, because Margaret paid Alex, the next question would have been, would it have meant that Margaret can sue Alex for a defect, for something that occurred while Alex was, trying to protect the house? But again, we're kind of running out of time. I've got a tutorial at 7:15, so I'm going to have to end this tutorial right now. Okay? So if you have any questions, please feel free to send me an email. Yep, so we've got the 4-corner rule. Thank you, Peter. We're going to have to do it again because I've got a class in 3 minutes in administrative law. Thanks, everyone, for participating and engaging in this tutorial. And if you have any questions, please feel free to send me an email. Okay, thank you and good night. Bye.